everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express
my gratitude
for all the many things?
all the many things you've done for me?
Words are not enough,
Words are not
yeah.
enough to say thank you.
So Lord, you are my everything.
You're
One
my
more time.
everything.
How can I express my
How
gratitude
can I express my gratitude
for all the many things,
all the many things you've
Father,
done
you
for
done for
me?
me, yeah.
Words are not enough to say thank you.
So Lord, you are,
Lord,
you
you're
are.
my
See,
everything.
I call you Jireh.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
You're my everything.
I call you Jireh.
Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
You're my everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya.
Hello, hello, hello. Lovely good afternoon to you. Another Saturday is with us, and we are live on the program, The Community and the Law. My name is Owusu Frimpong, and this afternoon I have a very interesting and important discussion to do with you. You remember last week, if we were on the show, I asked you to do some calculation. Now, today we're going to look and follow at some practical steps to take when it is that we're doing one particular application. And that's brought to you by BWF Solicitors, our trusted friends when it comes to legal matters, especially our immigration matters here in the UK. BWF Solicitors, 214 to 218 Tottenham High Road, Seven Sisters, North London. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340 or 077 127 61884. Ladies and gentlemen, my brothers and sisters, let's jump into it together live on BWTV and BWF Solicitors social media platforms all around you. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner with over 30 years of unbroken service to the community is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back, and thank you very much for joining us. Naomi Buani, thank you. Wimpuni Adam, welcome aboard. Doris Amankwa, you are on board. Perfect law firm, reliable. That's what you say, and you use that in describing BWF Solicitors. Sandra Fraser, good afternoon to you as well. We have Wimpuni saying hello. Naomi Buani, you said good afternoon. Sandra Fraser, yes, you've done what you do all the time, giving us the details as to where we can locate BWF Solicitors. I would want to give you another clue. If you travel on the underground, you get on the Victoria line, get off at Seven Sisters, use exit number 2. It takes you to the frontage of the building known as the Anna House. BWF Solicitors is on the 4th floor. Now, if you are in doubt, just give them a call 0208 493 7340 or 077 127 61884. BWF Solicitors with over 30 years of experience behind them. Man, you are so covered and you have a reliable friend. So get to BWF Solicitors. Now this afternoon, I'm bringing you the very, my Niger, my traditional people will say the very ogo, the Oga Kwata Kwata coming on the show this afternoon. The senior partner, the principal of BWF Solicitors, our guest this afternoon, and I have the singular honor and privilege to introduce to you my guest and resource person from BWF Solicitors, lawyer Bernardo Usu. We call him Uncle Ben. Uncle Ben, good afternoon.
Hi, Kweku, good afternoon.
Oh, lovely sunshine behind you. Well, thank you very much for making time for us this very lovely Saturday afternoon. How's the family and everybody?
Well, doing absolutely fine. We're grateful. Today looks rather sunny. And it's an amazing day. It's my son's birthday as well, so
Oh, wow.
it's quite
There's
special.
happiness all around you.
I know.
We wish him all the best, and
I'll tell
we
him.
believe that the good Lord will continue to bless him, and he
I'll
will
tell him.
jump to greater heights as you have set the trail for all of us. Well, having introduced my resource person, my guest this afternoon, ladies and gentlemen, let me do what I will describe as the housekeeping. Housekeeping in the sense that, one, I want you to like the page. If you are new to the channel, subscribe to the channel and click the notification button so that when we put on content, you will not miss it and you'll be there. But whatever rose your boat, if you would want to keep the link and watch the show later on, yes, that's fine. Or you can join us whilst we're doing it live right now. Chiwo, thank you very much. Good afternoon. Now, the second bit I want you to look at is the nugget that is put out every Monday morning. Now, this is an opportunity for you to know what's going on when it comes to legal matters here in the UK. It will involve your immigration matters, your settlement, what benefits you can get from the community and from the local authority that you come under, or what it is that you need to know that's coming up when laws and regulations are changing. Now, this afternoon, we're looking at one thing that's known as the no recourse to public funds, NRTPC, maybe, or NRPF. That's how people will describe it. It is an immigration condition that stops people from accessing benefits, also called public funds, such as homelessness assistance and universal credit. However, social services have the power under Section 17 of the Children Act to provide financial support and accommodation to the family of the child in need. This support can be provided to the child's parents. This one is quoted from R on the application of OA and others versus Bexley LBC 2020, EWHC 1107. It's an admin case. So, no recourse to public funds. What are public funds? Why is it that people are not allowed to have recourse to public funds? And if that is so, the exception, where does it come in and who benefits? With that, I will go over to my resource person, my big brother, and our principal, Uncle Ben, to help us unpick these things and understand it. Uncle Ben, no recourse to public funds. What are we talking about?
Well, Kweku, as you know, when anyone is given status, lawful status in the UK, there are what we call immigration conditions. One of the conditions is whether or not you can claim public benefit or whether or not you can't. So what the law has done is that those people who are not allowed to claim, they put a special condition in their vignette or on their vignette or their biometric card at the back of it, and it will say that you don't have no recourse to public funds. What it means is that those benefits that are classed as public funds under the immigration rules, specifically under paragraph 6, and this will include social housing, universal credit, pension credit, working tax credit, all the benefits that we know. There's certain benefits which are not, which are means tested. Those ones will not be classed as public funds. Going to university and getting university fees, assistance grants is not public funds. So that will not affect, that should not affect you. But I know that sometimes they use the law on the fact that you're not settled. Again, if you're renting privately, again, that will not affect you. So it's one of those conditions that has caused a lot of problems in the community. That is why when we have the opportunity, we like to emphasize why it's important for those who have those conditions to see whether they can remove them, and if they can't, whether the local authority will have a duty to support them.
Well, Uncle Ben, the question obviously is, if I live in this country, I have a right to work, and I contribute to Social Security or National Insurance. I go to the GP, they charge me for some of the services for medication and the rest of it. Why is it that when I contribute to the development of the community, they exclude me from having to benefit from the pot?
Well, I think the excuse has always been that the benefits is for those who, one, need it, and two, that have contributed into it. So you remember that I said certain benefits are not affected. So for example, if you work, but you've got limited leave to remain as a skilled worker, and then you are on a statutory maternity, you will get your maternity allowance from the government. Again, if you're unwell, you will get sickness benefits or statutory sickness benefits from the government. Those are contribution based, and you've paid into it, so you get it. The same as pension, but pension credit is a benefit. Pension is not a benefit, pension credit is. And that is why they say that in most cases, you should be able to support yourself without recourse to public funds. And the rules have categorized those areas where you need to be able to support yourself. So if you look at all the limited leave areas, any leave that is not settlement, so all the 5 years, for example, under the EU, they don't put any restrictions on you. But when you come to the immigration rules proper, you look at any of the Part 8, which is family and private life applications. You go to the annexes, Annex Appendix FM, for example, Annex SW, which is a skilled worker. All those will have an inbuilt requirement for you to be able to support and accommodate yourself. And that is why you don't have automatic access to public funds. It doesn't mean that you can never have. As I've said, I think a couple of weeks ago, during our program, we did discuss how the condition, your changing conditions will not affect the track that you're on, whether you're on the 5-year route or you're on the 10-year, if you apply to have the condition varied temporary. So Kweku, it's a condition of the immigration rules. It's a requirement that you have to meet.
Well, the law says no recourse to public funds is an immigration condition, as Ben has explained. Social services, as he has also explained, have the power to vary the condition and provide financial assistance and accommodation to the whole family of a child in need. That is a Section 17 provision. So if Section 17 let me come back quickly to ask this. Section 17, can it cover any child at all, irrespective of their immigration status or the immigration status of the parents?
Yes, it covers all children that live in a certain locality. So if you take Section 17, which comes under the Children Act, it's a welfare protection to ensure that children that live in this country are not unnecessarily burdened because their parents are unable to provide them with accommodation or food. So the Section 17 is a mandatory duty on the local authority to ensure that any child that lives within its locality is not unnecessarily burdened. So if you're here, whether you've got status or you don't have status, you can always go to the local authority for them to assess you and determine whether you will qualify for this benefit. As I've always said, we must not allow our children to go through unnecessary grief and trauma. Grief and trauma usually will be found in situations where a mother is not able to provide food. They don't have a place to sleep or lay their head, and really they are jumping from bed to bed or friend to friend. And sometimes these children are exposed to predators. It's very important that if you're a parent and you don't have food, you don't have accommodation, whether you have status or not, you must go and see the local authority. What I know that some of the local authorities will fob you off. There's a local authority I know that is spent over 600 million on a botched deal. They've lost 600 million pounds. And even the bean that they have to collect, they don't collect on a weekly basis. Now they do it once every 2 weeks. And local authorities like that will always fob you off and say, nah, you haven't got any status, so we can't help you. My advice to everyone is that don't take that. Go on and say, I'm making an application and I want you to assess me. We've done a whole 2-hour program on this before. But if we find that it's a recurring problem in the community, then we will come back and discuss it again. But yes, any person, anybody who has a child in their care, either a parent or a guardian or a carer, will be able to go to the local authority for a Section 17 support.
Well, if you just joined us, we're live on BWTV and also live on BWF Solicitors, all the social media platforms around you. And the Community and the Law is the name of the program. Tonight or this afternoon, we're looking at practical steps to make a successful settlement application for your child to join you in the UK. How do you go about that? Get your pens, your papers ready, and invite people to come join us as we go live into the discussion right after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back, and thank you for your time. I mentioned earlier on that by courtesy of BWF Solicitors, we're going to look at some steps to take and what actually the lawyers do to help us with such applications. Practical steps to make a successful settlement application for your child to join you in the UK. And I mentioned earlier on that we're doing that courtesy of BWF Solicitors. And this afternoon, we have the main principal with us, lawyer Bernard Owusu, to lead the discussion, and we'll look at that. Now, settlement application, maybe as I often do, we kind of unpick all those things. So let me bring in again lawyer Bernard Owusu. Uncle Ben, settlement application, how different is it from somebody coming for 2.5 years, somebody coming for 6 months, or somebody coming to stay forever? What are the differences?
Okay, so the difference is that if somebody is on a settlement track, then the person's leave will lead to settlement. So all skilled migrant programs, if you're coming either as a nurse or a doctor, or you're coming as a carer, or you're coming as a husband or a wife, or you're coming as a child and your parents are on limited leave, although you're given 2.5 years, you are on a settlement route. And then there are those who are coming under a 297. A 297 is for people whose parents are either British or settled in the UK, and then they're coming for they're getting settlement straight away. Or there are people who are coming under a 301, which is a limited leave to remain, or 310, which is what we call the adoption process, or 309, which is the adoption, which is not full adoption. So all the tracks that I've mentioned, they are all called settlement applications.
Okay.
Although you will get 2.5, it leads to settlement. So they put you on a settlement. There are those who are coming here on a temporary visa. Those are the students, short seasonal workers, agriculture workers, visitors, and people who are coming for medical treatment, and people who are transiting. All those people are what we call temporary migrants or temporary visa holders. The difference in those who are coming for settlement, you will see in their visa, when you make the application, it will say settlement application. And for those that don't lead to settlement, it will not say settlement application. So although a student visa will start with maybe a year or 2 years straight away, or 3 years, usually it's not a settlement application. But somebody may start on a 2.5, and that's a settlement application.
Okay, right. So, what problems do people have? Why do people get those applications wrong?
Well, as we've always been saying for so many years now, as with everything, you need to prepare. So preparation in these areas is quite key, and most people do not prepare. So the only time they may do anything that has a semblance of preparation is when they're making the application. These programs that we do is to educate the community.
That's right.
We've been doing this, and it's helped so many people. We come and hit the same area sometimes because we are noticing a repeat action or a trend, and therefore we try to correct it. What we have noticed, and when I start, I will break my discussions into two. What we've now realized is that people are going back to the old bad ways, and that's why we want to draw everybody's mind back to where we brought everybody 3, 4, 5, 6, 7, 8, 9, 10 years ago. And we've been doing that, and it's been working for the community. Because Kweku, if you made attempt to reunite with your child and it's not successful, it drives families mad. I mean, I've seen situations where people have been given bad advice, and then when you get involved and try to correct it, it becomes sometimes almost impossible because the harm has already been done.
Been done.
So this program today is to make sure that we provide the necessary information and also written documents that we'll show you later, not now, which you may copy if you want, to help you with your journey. The children application is fraught with difficulties. There's several difficulties, but the most difficulty that people face is a suspicion that the child is not your child sometimes. So that we've advised people to do DNA if the birth certificate is recent. But the other thing that we want to highlight is what I will discuss later once we open up the program and go into full focus.
Okay. All right. Thank you very much. And I believe that, as I said, people should get their pens and papers ready, get your notepads ready. If the information that will be put on there, if you want to copy, go ahead and copy that. But all in all, please remember that your surest point of contact is BWF Solicitors, 0208 493 7340 or 077 127 61884. Now, Uncle Ben, we are ready, and we know that you're going to put on your professorial cap, and you're going to tell us what practical steps we need to take.
Okay.
How do we
So
start,
fir-
and how do we get along with it?
Okay, so first of all, I'll open the topic. Now, what I'm going to discuss refers to those who are bringing their children, either they've got 2.5 years, either as parents or partners, or those who have settlement or indefinite leave who are bringing their children, or those who are also bringing their children under the EU requirement. And then I will separate that from those who are bringing their children under the skilled worker route. So it's going to be a full-blown discussion.
Okay.
The first thing I want everybody to focus on is that when they say under immigration rules that you're bringing your child, then you're bringing a child under 18 years. And under the EU route, although it's now part of the immigration route, if they say you're bringing your child, and it could be a child who is 50 years, but they are called your child. So they are family members under the Appendix EU SS.
Okay.
Finally, if we say you're bringing your child under the skilled worker route, it may be your child or your stepchild. There are difficulties that we've now identified with the skilled worker route. Again, I will focus on that once I've started. When you come to those who are bringing their children for indefinite leave from their home country, the relevant law is Immigration Rules, paragraph 297. Paragraph 297, we have I as eligibility route. It talks about A, it talks about B, it talks about C, it talks about D, it talks about E and F. My focus will be on the E and the F because the other ones everybody knows that when you're coming, you must have an accommodation, you must have the means to provide for them. The E says that if you're bringing a child here under the immigration route and the child's parents both live in the UK, then all you have to show that you have the means and accommodation, the maintenance and the accommodation to provide for them. So that's not difficult at all.
Okay.
When the problem starts as a two-family relationship. So when I say two-family, where you've got step, or it's one single parent who is in the UK, and therefore the issue of sole responsibility arises. In those cases, it's very, very difficult to be successful if you haven't planned. Planning involves you showing that you still have interest in your child. When you look at the latest Home Office guidance for its caseworkers, which is a May one, I think it's version 11, it clearly puts emphasis on 5 thematic areas. 1 is finance, 2 is medical, 3 is religious, 4 is education, and 5 is any other activity, including holidays, friendship, and network. You will have to show that in these 5 thematic areas, you are able to pinpoint with evidence that you've done all. So we take finance. How do you show that you have supported your child whilst you've been here? Usually it will be money transfer receipts. And when I say money transfer receipts, I mean money transfer receipts with names on. Now, because the person is a child, I'm not talking about the EU, I'm talking about the UK immigration route, pure immigration route. Because the person is a child, sometimes you cannot send the money directly to them. So it means that the money will have to be sent through a relative. This is what I always advise our friends. So when you're sending money, you could put a reference on it. Unity Link, TapTap, and the others have provision for that. Make sure that whatever money you are sending, you identify the money that is for Kojo Menu and is for Kojo Menu's fees. And I said Ekuya Mansa and it's for Ekuya Mansa's fees. Okay. So you can identify that. The other thing that I want people to know, that even the case law, case of TDEMN, we look at it, the Home Office guidance, which is as old as 2001, which talks about sole responsibility and proving sole responsibility. And the latest guidance notes for parents and partners, which is the May case guidance that I referred to, they both put emphasis on having continuing and abiding interest in your child. How do you show that you've got continuing and abiding interest in your child? You call the school regularly, the school writes to you, you write to the school, you speak to the school, you travel to Ghana, you go and see your child. So that is education. I mentioned 5. Health. When the child is unwell, they go to hospital or clinic or polyclinic or compound chip or some other place, or they go to the pharmacy or the chemist. These are people that you can have communication with. And I will show you why it's significant. I will show you. We'll show you a case that we got a decision on the 31st of March. Not now, we'll show you later once I've done my presentation. The other thing that I also want you to focus on is that this is evidence-based. Because when you look at a case of TDEMN, what a court said is that when you come to the assessment of sole responsibility, it's fact sensitive. It's only factual. Facts can be word of mouth or documentary. And that is why I always tell our community that once you step foot in the UK and you've got a child in Ghana, you know one day you will bring them. So start gathering your evidence, start speaking to the school. How do you prove this? This is how you prove it. First of all, you can ask the school, you can ask the hospital, and we can show the letter that we use that I drafted. I'm happy to share. This is something that is created after a long research, because we see, when we see trends, we react to it. Sometimes we get ahead of the trend. Sometimes we get behind. But whatever we do, this letter that we're going to show is a letter that we've sent to a doctor or hospital. It's a similar letter that you can send to the school or the church or the mosque. Ada, if you can show that letter, I'll be grateful. So if you look at a letter, it's quite simple, but it talks about what is relevant. So see, this is what it says. Now, I'm happy for you to copy, whether you're a lawyer or you're an ordinary person I don't have a problem, okay? So you see, we act for the above named applicants in relation to the application to travel with their mother to the UK. As part of the application, they need to show that their mother has sole responsibility of them. And she makes all the major, now you see there are specific words that we're using.
That's right, yeah.
She makes all the major decisions in their life, including decisions about, you see the thematic area, education,
health, religious
and other relevant
issues. Yeah.
But we don't just put these things in there. We put these things there because case law and the Home Office guidance says that they want to see this. We have been instructed that, and the name of the child is there, another name of the child, attend your hospital, and you have been in charge of their medical care. Would you confirm, and this is critical, would you confirm that the mother calls you regularly, and also confirm that the other parent has never contacted you as far as you're concerned. From your professional view, you can confirm that the other parent is not in their life.
Okay.
Would you also confirm that in your professional view, in relation to their medicals, it is the mother who makes, or again, look at the word and phrase, major decisions in their life, insofar as she brings them to the hospital and pay all their hospital bills. In addition, you pass on information about the children's medical and health requirement to her. Hope to hear from you. Now, the way this letter is written by us. Ada, you can take it off now because I'm sure it's been copied. The way this letter is written is to elicit information. And the information that we want to elicit is health, is religion, is education, is well-being, and other areas. So
Now,
this is what the Home Office
maybe just to quickly preempt something.
Yeah.
The organization that this letter is addressed to, are they obliged? It's coming from a legal firm. Are they obliged to respond?
So, in addition to this, if I am doing, the reason why we haven't shown the other one is if we are doing it, we have to send an authority from an adult.
Okay.
So it will be authority from the mother or the carer or the father if we're acting for the father. But in this case, if you're acting on your own for your child, this is the only letter. So when you end, please don't go and write BWF solicitors. That one is us. You put your name under, because I know what people do. They will just go put BWF solicitors there. Now, this letter does so many things. When you look at the letter carefully, it's ordinary letter. There's nothing in there which makes it anything special. But the emphasis on certain phrases and the word "in your professional opinion" is key.
Right.
Because if you are a school, and this was addressed to a church, there's one we addressed to a mosque, there's one we addressed to a chemist and a pharmacist, there's one we addressed to a hospital, another one we addressed to a school. But if you're a professional and you've been asked to give a professional opinion on something, that opinion, although it's your opinion, it is professional opinion. And therefore, it cannot easily be challenged by the Home Office or in court. If this were to be put before a judge, and the letter is written by a nurse, a teacher, a head teacher, a reverend minister, a doctor, a healthcare specialist, a psychiatrist, a psychologist, an imam, these are specialist professionals. And when they say that we can confirm that Islam, Araba, comes to mosque regularly, that Miss Araba calls regularly to check on their religious progress, that in our professional opinion, there's one that the Imam wrote, in our religious
opinion, obviously.
That's what he said. But in our professional opinion, we can safely conclude that because of our dealings with the mother, the father is not in their lives, and she is a person we know has sole responsibility for the children. If you've got the one from church, one from school, one from hospital, one from chemist, you've got 4 or 5 items. It's very difficult to defeat this wealth of evidence that you provided. But I say this, if you've got anything else that you can use to support it, you might want to think about getting another professional, which is a social worker, an independent professional social worker, because an independent professional social worker is used by courts in this country. So when we go to court in children cases, when CAFCAS is instructed, the person who prepares the CAFCAS report or the person who does the section 47 report will be a social worker. In the same vein, if you pay a social worker in Ghana, they will go to the child school, they will speak to the treating hospital, they will go to the church, they will go to family home, they will prepare an assessment with images, and they will prepare a professional report and say that in our professional opinion, the other parent is not in the child's life and is the mother who's been taking all the major decisions. Now you can see that we're not saying all decisions. We say all major
decisions.
Now, somebody will say, well, you live in the UK, your child lives in Ghana, lives in Timbuktu, Cambodia, Trinidad, Tobago, Jamaica. How do you take the decisions? So you take a decision through an adult. These children will normally be living with an adult. So what you do is that you exhibit your phone calls with this adult, your WhatsApp messages, your emails with this adult, you giving them instructions. So this adult, again, will also write a letter that I, Nana Wusu, of number 22A Cantonment Street, Accra, I am a friend to Mr. Nana Owusu in the UK. When Mr. Nana Owusu left Ghana 5 years ago, he left his 2 kids with me because we are friends. I have been taking the children to school and passing on information to them also. But I can also confirm that their choice of school and treating the hospital, their choice of religious education is done by Nana Owusu. I speak to Nana Owusu regularly. He sends me money for the children. They are corroborating what you're saying on the application form. And as you can see, there's a lot of work that goes into this. Now, I don't take lightly when a parent comes to me and say, I want to bring my child. We are very thorough. And sometimes the parents complain, Uncle Ben, this thing is taking
you're
too
too
long.
strict.
Even, I know, 2 days ago, someone said, Uncle Ben, my case is taking longer. It's taking long for good reason. It's taking long because we want to be thorough. We want to cover all the grounds. We just don't want to put in an application just for putting in it. If it's just to make an application, we'll make it. What I've said here, that this case that we did is for a skilled worker who was joining her husband. So in that case, as you will know, if it's a 2-family application, so the main applicant is here, is married to the mother of the children, but the children are not his children. The guidance notes on dependent children says that where the main applicant is in the UK or coming to the UK, and he has children from other families, so the wife has children, then the wife will have to show that the parent who is a skilled worker has joint parental responsibility with them. And again, you will be able to collate this evidence from the specialist. So, Kweku, as you can see, I will exhibit a case law and you will see the application of that. So, Ada, if you don't mind, I hope we've redacted all the confidential information on there. If you don't mind, you can show us the case law. There's a case that we won recently on the 31st. If you blow it up a bit, you can see that the date of the decision is 31st of December. Go to the bottom of the decision. The bottom. Go to the bottom. Okay, so when you say, you see to the respondent, as I have allowed the appeal, and because a fee has been paid or payable, I have considered making a fee award, and I've decided to make a whole fee award of £140 because the appeal was allowed on the grounds pleaded. Go to the beginning. Now, you can see that this case was done by us. Go down a bit. You can see the representative. You can see BWF solicitors there. Now, as you can see, the appellant is a citizen of Ghana. She appeals the decision was appealed on the 17th of June 2021. They refuse a human rights claim, but this is a 2.5 years this is an indefinite leave under paragraph 297 to join her mother. Now, when you go down a bit, let's go. These are the facts. The appellant birth was not registered contemporaneously and it's not accepted that the birth certificate established her parentage as claimed. There is insufficient evidence to demonstrate that the appellant's father plays no role in. So this is the Home Office making all this allegation. There's no medical evidence to show that the appellant's grandmother's health means that the current care arrangement cannot continue. It is not accepted that the sponsor has sole responsibility for the appellant's upbringing or that they are serious or compelling. But let's go back down. Let's go down. So you see the law. Let's go back to the law. You see the law. The relevant provision of the immigration rules is paragraph 297. It is for the appellant to show on the balance of probabilities that she satisfies the provisions of the rules. Insofar as she relies on Article 8 outside the immigration rules, it is for the appellant to show that Article 8.1 of ECHR is engaged. Now let's go to the application of the rules. Finding and reasons. There are three issues in this appeal, and this is crucial. Whether the sponsor has had sole responsibility. This is what I've been hammering on all afternoon. 2, whether there are serious and compelling or family other circumstances. This is what we call the 297IF. 3, if not, is the appellant's decision unlawful under Article 8. 11, the sponsor was a credible witness, and this is key. Kweku, when you're presenting your evidence, you have to sound credible. There's a case that I've mentioned this afternoon. I've mentioned it, T.D. Yemen. You see it at paragraph 12. And let's read what T.D. Yemen says. T.D. Yemen says, sole responsibility. Kweku, what does it say? It's a factual matter to be decided
upon all by
upon
all
what?
evidence. Yeah.
So everything that I'm hammering on about is the collation of, not collection, collation of the evidence. Collation of the
Collecting
evidence.
them, putting them together.
Absolutely. And making them credible, because they
right.
have to be credible, because they're going to be tested against the weight of the Home Office assertion. Let's go. Let's go to the findings. Let's go. Let's go. Let's go. Okay, stop there. Stop there. Stop there. Stop there. In her oral evidence, the sponsor provided an update about her mother's circumstances. She stated that she has had to ask her brother to go and stay with mother to care for her. In addition, the friend who had cared for the appellant had stated that she will no longer do so. Because you remember that when I was saying Nanohusu was saying that Nanohusu are looking after Nanohusu's children. This is how it plays out in court. Let's go down. Let's go down. Okay, the sponsor.
Go a bit up. Go a
It's
bit
not
up.
disputed
22.
that the sponsor has been paying the appellant school fees. Right? The appellant's evidence as to who is responsible for meeting her needs is very clear.
Very clear.
In this case, we made the child write a statement.
Oh, okay.
Let's go down. Let's go down a bit. Let's go. Let's go. Stop. 26. Kweku, read there for me.
I find that even the appellant's grandmother had been exercising day-to-day responsibility for meeting her needs. This has been done on the instructions of the sponsor. On the basis that it is the sponsor who makes decisions and the appellant's grandmother merely gives effect to those decisions, I have no hesitation in finding that the sponsor has had and continues to have sole responsibility for the appellant.
Kweku, and this is the joy of preparing a good case.
That's right.
Now you can see that in this case, the judge found that the grandmother has been exercising day-to-day responsibility. So when we talk about major decisions, look at what the judge said again. He said the grandmother has been doing this upon the instructions of the sponsor. 27.
27 says the appellant enjoys family life with her mother. The respondent's decision causes an interference with the enjoyment of a family life. I am satisfied that the likely consequences of the interference are sufficiently serious as to engage Article 8.1 of the ECHR.
Okay, let's go to
28.
Let's go.
At paragraph
Let's go.
34 of his decision in TZ Pakistan and PG India versus SS80 2018 AWCA CIV 1109, the Court of Appeal held that where a person satisfies the rules, whether or not by reference to an Article 8 informed requirement, then this will be positively determinative of that person's Article 8 appeal, provided their case engages Article 8.1, for the very reason that it would then be proportionate for the person to be removed. Accordingly, I find that the respondent's decision dated 17th of June 2021 is disproportionate and is unlawful under Section 6 of the Human Rights Act 1998 as being incompatible with the UK's obligation under Article 8 of the ECHR.
And what is the notice of decision?
The appeal is allowed on human rights grounds. No anonymity direction is made. Dated the 31st of
Absolutely.
August 2023.
And this is just last week, Thursday, I think.
Yes.
Ada, you can take it off. So, Kweku, now, this is to show the practicality of the theory that I've been espousing all afternoon. So I've been talking about major decision making, delegated decision, getting professionals to give opinion. This is what it leads to. It
Right.
leads to a very juicy, positive decision in your favor. All the work that you should have done that you didn't do, you can still do them now, but it has to be done with clarity, with purpose, with intentionality, and with competence. And all that we do, as I always say, is to bring to the knowledge of the community. This means that if somebody is making an application to bring their child, they know that if it goes to court, these are the things that they are going to consider. So now that Uncle Ben and BWF solicitors are saying that this is how to collate this evidence, they will put it in their practice, and we will see less and less bad decisions or bad applications being made by our compatriots and our community. Kweku, this is where I bring this to a stop.
Well, thank you very much, Madam. Let me ask a very interesting question here. The evidence that's presented in an appeal or in court when these decisions are made against applicants, can we say the more the better?
Yes, well, it's not just throwing evidence into the pot, it's throwing one relevant evidence.
Okay.
Relevant evidence. So those of you who work with me and have worked with me for years, they will tell you that when I come to you and you're preparing a case for court, the first thing I'll ask you is that, is this evidence relevant? When we talk about the rules of evidence, there's something called the relevance of the evidence. And if the evidence is not relevant, although it's evidence, it's not relevant to the case. What can I say? For example, if I'm doing a 297 application, the decision is under a 297 IE or IF, which is compassionate circumstances.
Right.
The decision says that my child is not my child, okay? Because the birth certificate, my child is 17. The birth certificate was made when the child was 16 and a half. So how come it's taking over 16 years to get a birth certificate? Now, what would be a relevant evidence would be if I have a baptismal certificate from her birth, or have an old handwritten certificate from her birth, or get a DNA test done. Just getting other people to prepare statutory declaration from friends and family to say that, oh, I know Auntie Ama, when they were selling mango around this area, I saw Akuya walking around her, so I can say that Akuya is her daughter. Or you get a school to write a letter to say, oh, well, Akuya has been coming to school, so we know it's Auntie Ama's child. That is evidence, but is it a relevant evidence? The relevant evidence will be something that is produced which confirms that the child is your child, which would be a birth certificate, and above all, maybe a DNA test. So it's not just putting in a lot of evidence. It's putting in a lot of relevant evidence that goes to the root of the issue. Because in law, when you're doing or applying for any case or going to court, there are issues. So you have to identify the application I'm making, what is the issue, or what are the issues in this case. The issues will help you prefer a solution, because the issues are the problems in the case. And what you're providing is to solve that problem. That is why you just don't throw anything in there.
All right. Well, folks, if you just joined us, we're live on BWTV, and the program is The Community and the Law. Our guest and resource person is the senior partner and the principal of BWF Solicitors, 214-218 Tottenham High Street, North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340 or 077 127 61884. Now, David Samoa, I have your question that I'll be putting on there. But before then, Kwame Atajima is watching us from Paris. Then Mununkum says, friends and family, good afternoon. I have Edward Mensah. Good afternoon. You're welcome. Margaret Mensah. Good afternoon, Uncle Ben. And you're asking everybody to share the program. Yes, that's what I'll practically ask you to do. Share, 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 and share until everybody gets it. But if you would want to push it to later on, you can pick up the link and watch the playback later on. I have Namayati. Greetings to you and the family. Now, how are you? We believe you so very well. We have our folks also watching us. But there's one text from YouTube that I wanted to bring up. Let's see. Anyway, our friend who's watching us on YouTube and all those watching us on all these social media platforms. Yes, Kosia Akwe, you're watching us from Birmingham. That's what I wanted to say. Well, folks in Birmingham, thank you very much. And you know what? One of these days we'll be bringing our program outside for you to sit in an audience and we broadcast it around so you can ask your questions directly and face to face with the lawyers, especially when we have Uncle Ben and the rest of the lawyers around. You can now join us via text or you send your comments down to the bottom of the page, the comment section, studio number 07399208468, or you can send a WhatsApp note and a voice note, so to speak, on 0795042278. So go to Facebook, go to YouTube, go to all the social media platforms and leave us your comment there. Uncle Ben is here and he's ready to answer all your questions. Well, I've got a few of them on our text messages. We'll be bringing that. But our friend who had one there, let me quickly pick that one up and see if we could get Uncle Ben to quickly look at that for us. David Asamoah, yes. David, you said, can one add additional documents to an application after submission and biometrics considering a settlement application? So when the person has put together the documents, the evidence, is sent the application in, can you later on go to say that I forgot X, Y, Z, so I want to add?
Well, quite cool. You can always add any new evidence that you have.
Okay.
So before the decision is made, I always advise that if there's any evidence that you want the caseworker to review, then this will be the best time to send it before a decision is made. So yes, you can do that. Yes.
Right, and is it not going to kind of push your case to the bottom of the queue?
Oh, no. Now, once they start considering the application, until a decision is made, anything that you send will be part of the application process, and they are obliged to consider it.
Right.
Sometimes, if you don't send that evidence, they might ask for it, and clearly that can also affect or delay your application. There's a case that we're doing, and we've been asking for evidence for so many months now. Unfortunately, the client is not managed to, but finally she's got it. So yes, it's been sent. You can always send it. I rather have a delayed decision than a bad decision.
Okay.
And I've always explained to everyone that it's not the speed at which the application is made, it's the competence at which the application is made. Firms are very, very busy. Lawyers are extremely busy. They don't deal with one case. We deal with multiple cases at a time, sometimes several hundreds, at a time. And everybody's case has the same thing, and it's always first come, first served. So when a lawyer is dealing with your case, he's dealing with your case on the basis that he wants to win. That is why we do, I won't say no lawyer. Good lawyers will always prepare your case to win. You don't win all. I would be a liar to say you win all. But if you're clocking over 97, 98% success rate of your applications and appeals, then it means that you're doing something really good. And it's what we do that we also bring on the program, because when we come on the program, I remember last week one of our clients sent me a text. I go back, but you're doing your work free on. Yes, that's the import of this, and
Mhm.
that is in 1999 when I started this process. I've never hidden anything. Any trick that I had under my sleeve, I put it for people to learn, and it's helped many, many people, I must say, yeah.
Right. Thank you very much, and more grace to your elbows. We're all testaments to that fact. Let's go on to the platform and pick up this one from Nanachi Ahene. Nanachi Ahene says, how can Anglia DNA help with DNA tests if the parent is in the UK and the child is in Ghana? Talking about Anglia DNA, they've got representatives in Ghana. Dr. Hazel has got representatives here in the UK, back in Ghana. They send people, competent people, to go to wherever your child or your relative is to collect the samples. They'll process that, and they're trusted by the Home Office. So Anglia DNA, yes, I can vouch that they are really good with that. So trust them and work with them. So Nanachi Ahene, don't worry. They are here in the UK, but they've got representatives in Ghana, and they've got professionals that take out the samples, as I've already explained. Moving on, another one down here says that, hi, please, I got my 2.5 in March 2016 on the 10-year route, but we'll go for the last 2.5 in December 2024. When can I get my indefinite leave to remain? I have to wait till the end of the 2.5, or I can apply for it in 2026, please.
Okay, so when you count your lawful residence, you count it from the date that you receive your first 2.5. So what I've always told everyone is not the date on your biometric residence card. It's the date that you got a first email to say you've been granted 2.5 years under the 10-year route or under the 5-year route. Most people will have an overlapping biometric residence card or overlapping leave to remain. It doesn't mean that you have to wait to exhaust all the leave to remain before you move on to apply for your indefinite. Once you've done your 10-year lawful residence or you've done your 5-year lawful residence, even if you've got overlapping leave or a leftover on your card, you can still make your application and it wouldn't affect you.
07399208468, or you can send a WhatsApp message or text to 07950422780. Uncle Ben, please, can you give us a tip on living together and application? On living together and application, I don't know. Maybe you're talking about couples living together and how practical they can make an application. Uncle Ben, can we get an answer for that?
Yeah, so when you look at the definition of partner under the Immigration Rules, paragraph 6, covers people who have lived together for at least 2 years before the application. So it covers areas like, if even for skilled workers, you don't have to be married to the person. If you can show that you've lived together for 2 years, then you will be able to make an application as an unmarried partner. That is different from a civil partner. I know that people make the mistake because in Europe, common law relationship are somehow recognized as civil partnership, a civil relationship, because I think in some European countries you can register your unmarried relationship. In UK you can't. But once you've lived together for at least 2 years, so whether here or outside, if you're here and, for example, you've got evidence to show evidence about it, official evidence. I don't like making applications and taking a risk and asking friends to just write letters. If you've got the evidence plus friends who've written letters, that is helpful. But it must be evidence like bills, utility bill, gas, water, electricity, council tax, tenancy agreement, bank statement, P60s, pay slips, employers' letters, and things like that. If you've got that and it covers 2 years, it's in your name, you've got some in your name, some in her name, or you've got in joint names, then of course you can show that you are in partnership, and therefore, although you're not married, you will still be considered as a couple.
Okay. If you want to call in, the number is 07399208468. or you can send a voice note to WhatsApp 0795042278. So when you call in, if you're not able to hold on, you can just send a text and we will call you back. That's okay for us. Again, let's see if we can get somebody speaking to us now. Good afternoon.
Hello, good afternoon.
Imagine that saying,
Me pacho nyanko pardon boko nam pacho moswe.
Nyame Adom Boko. Again, can you hear him?
Yes, I can.
Okay, all right. Boss, who question? Do you have any question for Uncle Ben?
Yes, please. A friend of mine, I have been following BWF for some time.
Okay.
Due to their good works, I have been watching the file, they do things. But in fact, I must use this opportunity on behalf of our people, especially from Ghana. I will use this opportunity to thank Uncle Ben and his team for the good service they are rendering to most of us because they are doing marvelously well. Although I have never been to their place to work on, but they are doing very well because education is better. Everybody needs education. Going to my question, a friend of mine just confronted me recently, being in a very devastated mood. The reason is he is on skilled workers visa, but I just don't know how he managed to. Hello?
Yeah, go on, we can hear you.
He is on skilled workers visa, but have managed to impregnate a lady who is here with the husband on EU. The woman is on is a pre-settled EU woman.
Okay.
So I just he wants to know that since this woman is pregnant, would there be any negative implication on him, or what may be the benefits on that? Because he is a skilled worker here with the wife and a lady.
So you mean this person is a skilled worker, has come with the wife, has impregnated somebody's wife who is pre-settled, EU pre-settled.
Yes, please.
Again, we have a conundrum on our hands.
Yeah, yes, I heard that. And first of all, my brother, thank you very much for the recognition. As I keep saying, we are community lawyers, and everything we do is influenced by the impact that we've had on the community for several decades. And for that, I'm very, very grateful. Now, so we go back to basics. If you want to deal with a case, you go to the bottom line. The bottom line is the law. So the law, he is on a skilled workers route. The woman is a limited leave or pre-settled status under EU. She's married to someone. So the child under British law will be the child of the woman's husband.
Yeah.
So when she goes to register, it's the woman's husband's name that will come on the birth certificate, not the philandering boyfriend. So that is one. The second part is, does it get any benefit out of it? Well, first of all, the child is your child. But if somebody is saying, well, can I switch from skilled worker to use my child because I'm not happy with a skilled worker? Yes, there are other circumstances that you can switch. For example, if the skilled worker's mother's husband, if the child's mother's husband has settled status, the child will have a British citizenship because under Section 59A of the British Nationality Act, the father of a child is the husband of the mother. So the child will get British citizenship. If the child is a child that has limited leave to remain, again, there are some benefits under Article 8, exceptional route, parent route that he can apply. But the practicality is that when she goes to register the child, the question that they will ask is, are you married? If she says I'm married, then they will put her husband's name on the birth certificate, which means that the child will have the husband as the father in this case. But clearly, these things do happen. We see them quite a lot. Most often than not, it works for both families. Because Kweku, as I've always said, you know, we live in a world where things change. We don't know why certain things happen, but of course it's happened. So when it's happened, what you do is that you find solutions to the problems. And the solution is practically that he should allow the process to go ahead and it will not impact his skilled status. If Home Office gets to know that a woman is obviously cheated on her husband, then of course that's something that they will look at. But as it stands, as I've said, if she goes to register the child, the father on the birth certificate will be the husband.
0739920848, and you can send in your text as well to the comment section. We have one there that we want to quickly pick, then we'll go to other ones as well. But if you want to do a voice contribution, you are allowed to do that now. I've applied for settlement for my children, Uncle Ben. They have received certificates of application. How long will it take for them to get the settlement?
Well, I mean, who knows? I mean, these things sometimes, you know, it comes quicker. Most times it takes a while. What I tell people is that in all things that we do, once you've done it competently, just exercise patience. And, you know, give it another 6 months from the COA, you should have a decision. And if it delays beyond that, you can always go back for explanation.
Okay. Next one, it says, Uncle Ben, please, I think the question came early on and sent in some further details. Can you please give us a tip on living together on application? The question is that the partner is illegal and I am not, but we have lived for 2 years. We've got some bills together, but my visa has run out. Can we make an application as partners?
Well, and nothing stops any application from being made, but you make an application to be successful. So the question is, will it be successful? There are conditions that will make it successful. Now we understand that one of the parties hasn't got any status. The
Right.
other party has status. They've got evidence that they've lived together. So by definition, under paragraph 6, they will be classified as partners. So they are partners. 2, if you are partners, when you make an application and you haven't got leave, you're making it under the exception route. The exception route is what we call the EX1. There's EX1A, which is children, and there's EX12. Sorry, there's EX1B, and then there's EX2. EX1B says that there is a relationship, and that the relationship is such that there are insurmountable obstacles that makes your removal, you know, unhelpful or not advisable, and that it's not reasonable to remove you because there are insurmountable obstacles. The insurmountable obstacles that we find are medical conditions. So, for example, if one of them has a medical condition that is chronic or that is terminal, chronic means that you may have. I'm not talking about tinnitus, which is a chronic disease, or some other mild disease like blood pressure. Those things are not terminal. When I talk about terminal, I'm talking about things like cancer, God forbid. I'm talking about things like kidney problems. So if somebody's on dialysis, heart problems, person has had surgeries, got a pacemaker in their heart or their chest, and those are the conditions that I talk. Or they're using EX1A, which is that there's a child in a relationship, and because of the child, whether it's your child or it's not your child, it doesn't matter. Once you're a parent or a guardian to the child, and parents sometimes include step parents if the other parent is deceased, then of course you can depend on the child. So it's not as straightforward as it is. Yes, they are partners, so they meet one of the conditions. The next condition is whether there are insurmountable obstacles because one person hasn't got status. So they have to show that there are conditions that they can meet.
Right. We've got another one here. It says, Uncle Ben, how much is the application for child settlement as indefinite leave to enter from outside of the UK? Do children pay IHS for such an application?
No, for settlement, nobody pays IHS. And settlement, by settlement, I mean proper settlement, indefinite leave. So when you're applying for indefinite leave, you don't pay IHS. So children come in, they don't pay. I know it's discounted for children, because we make many of these applications. I like to be at the end to review everything. So I will not readily know the fee. I will find, I'm sure one of my colleagues will send it to me. If I find it, I will tell you. But the IHS fee for children is not the same as for adults. It's discounted.
If you just joined us, we're live on BWTV. The program is The Community and the Law. This afternoon, we have looked at practical steps to make a successful settlement application for your child to join you in the UK. I know those of you who joined us a bit late. Tilly, I know you are late. Don't worry. You can watch it later on. We're finished. We're going to take another break and say thank you to BWF Solicitors, and we'll come back. We'll take a few more questions. Then we'll go to our quiz segment. That's the exciting bit I always get to when we have in this program. And I want to also remind you that we have entered September, the last 3 months of the year 2023. Remember, last year, the winner of our Christmas quiz in October is going to Ghana to enjoy his holiday. Oh, how I wish I was him. Listen, when BWF Solicitor says they deliver, and they're giving you everything for you to enjoy your life here in the UK, especially when it comes to the law, and of course, rewarding you for sticking and staying with them all throughout the year. And this December, there's another surprise that will be coming your way. So watch the space. BWF Solicitors, our trusted partners. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
And we are right back. And remember, we're looking at practical steps to make a successful settlement application for your child to join you here in the UK. Marisa Spersing is the main principal and senior partner of BWF Solicitors. Uncle Ben, you know what? If you have him like this, he tells you everything as it is, and you benefit. I know he's made a lot of pocket lawyers out of this program. That's exciting, but please do it right. And if you're in doubt, consult. Call BWF Solicitors on 0208 493 7340 or 077 127 61884. I'd say the numbers again: 0208 493 7340 or 077 127 61884. If you would want to know anything about the law, ask BWF Solicitors. If you want to understand how it operates, talk to BWF Solicitors. If you want proper representation with up to 99% success rate, talk to BWF Solicitors. BWF Solicitors, you can find them on the 4th floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters, London, N15 4NP. And for the benefit of those who are writing, probably I went a bit fast, 0208 493 7340 or 077 127 61884, 077 127 61884. Uncle Ben, thank you. Let's see if we can pick up a few more comments and questions. Anita says, asking for a friend. Okay, that's fine. She's on a dependent visa of a student, but he has switched to skilled worker route and added divorce to it. She has also got a certificate of sponsorship. So how long would it take for her to bring her husband?
Oh, okay. So, so this person, so that people understand, because some technical words were used. This person initially came here as a dependent of a student, and the person is now divorced from the student. The student is moved on, and this person has been given a certificate of sponsorship by another business. So let's say they've got residency here. They want to know how long they can bring their husband tomorrow. Now bear in mind that when this person came here, they said they were married, they brought a spouse with them. So if they're now divorced and they've met somebody and married a person, how long ago have they married this person? Is there evidence of genuine relationship? We'll do a program about, I think Charles did something, but we'll do a broad program about the way skilled worker assessment on dependence is going. Suspicion of marriage of convenience is rife. So we'll do a special program on it. So, in order not for them to say that there's a marriage of convenience, this person who is a skilled worker is here. They're divorced, or her husband is divorced her, or she's divorced her husband. When did she marry this other person? Have they met before? Those are the practical questions that I will be more interested in. If you're married today, you can apply today. Nothing stops you. You can go to the registry today in the morning, have a sign, and then go home, take your iPad or your PC or your laptop and make your application. Nothing stops you. But what I always tell people, it's not a fan of making application. If that's that, then there won't be need for you to use lawyer. You can just go and populate the forms. But it's just to make sure that whatever you're doing, you make a successful application. And successful application will require that they have to show that the relationship is genuine. So evidence of communication, knowledge that they've seen each other before, photographs if they've traveled to Ghana, evidence in their passports that they've traveled to Ghana. She or he has traveled to Ghana, met this person, and then they've married.
07399208468. One here says, when applying for your spousal visa for your wife, is it best to include her child from another person into the application, or is it better that she enters the UK, then file together for the child?
Well, Kweku, the exercise we've done this afternoon, if this person were listening or he was listening, then they wouldn't ask this question. Now, once you leave the child even for a day, then the issue of sole responsibility becomes a bit more difficult to succeed.
Yeah. So
if you have intention of bringing your child and you meet the maintenance requirement, which is 275, 320 for spouse, and then the other child I think is 250 or 200. You've had it in your account for 28 days. Bring them now. Bring them now. Bring them with you. Add them to the same application. Because even those who are doing that, they are still refusing them because they haven't shown sole responsibility. Where they have two families involved, the issue of sole responsibility always arises. And my advice is that if you have intention of bringing your children, unless the children are the children of the same man and the same woman, then that's fine. You can leave them and bring them later. But if it's different father to the children or different mother to the children, and you're married to a different woman or a different man, then you need to be sure that when you're making your application, you're making it with them. That would be the easiest way around this. That's how I find that it works better. But if you're here, you still want to go and bring them, you just have to go through the process that we've shown today. If you were not present, you can rewind the video and view, and then you'll be able to see the evidence that we've advised you to collate.
Okay. Well, Francisca says that is there any update on the settlement application?
Well, I mean, if you say update on settlement application, the only thing that we're waiting for is for them to increase the fees, which we're all waiting. We advise people to make the application. Settlement applications, skilled worker is a settlement application. The update on it is that they are, a bit more intentional now. They pay attention. I was just looking at their latest guidance notes, which is dated August, and they've stated in there that people should be called for interview if the caseworker is not satisfied with the documents. So those are some of the updates that I can give. But update, which may be a very significant update. It's only the fee thing which is still outstanding.
You can send your text to us 07950422780. That's our WhatsApp line. Or you call in 073-992-08468. You put that in the comment section down below, and we'll pick that one up and look at that. My name is Charles. I applied for settlement online and went to enroll my biometric at UKVCAS. To my surprise, they didn't take away my passport and biometric residence permit. Indeed, they scanned them and gave them back to me. My BIP expires at the end of 2024. My question is, since I have my passport and BIP, can I travel outside of the UK whilst my settlement application is under consideration, Uncle Ben?
Under our rules, when you travel out, you've withdrawn your application. I know people do. I know many, many people do. Even if you tell them they shouldn't, they will do, because a lot of them do and they are not caught. But many things happen. And as people will find, there are people who are still stuck in Ghana because of COVID. They did what you've done, what you say you may want to do, and COVID struck, and they are still stuck. And the saddest of cases that I know, and he's died now, and I feel so sad that it happened. There's an old man that I've looked after for so many years. He's been married his wife in the 60s. And, he lived there in the 60s, but he didn't get settlement. Went to Ghana, he came back. So we got him 2.5 and 2.5. And he fell ill. And for some reason, the family said they should bring him. They went to Ghana, and his card expired. And to get him to come back was a problem. We did everything that we needed to do. They gave him a vignette to come back, but the family said no, he needs to do his treatment before they will allow him. And now the old man has died. He died last year, I think. So please, the only application that whilst it's pending, you can still travel is your British citizenship. When you make a British citizenship application, although the application is pending, you can still travel in and out. But if you make a limited leave to remain or indefinite leave to remain application, they don't take your passport. They don't take your biometric card. Your passport will be scanned. You keep your passport. But if you leave the country, legally, you've withdrawn your application. So please, it's a very difficult thing to do, and I don't want us to be doing things which may give us problems in future.
Okay. Nana says parents who are both here in the UK but not in a relationship, my mother has sole responsibility. Can they still jointly bring a child if the father is on a 2.5 and a mother a British, but they are not in a relationship?
So in that case, they're bringing the child under a 297. 297, both parents are here, but the parents are not partners. So the issue of sole responsibility will happen. So you need to make sure that the steps that we've given this afternoon, you follow the steps to the letter. You make sure you get all your evidence, which says that the mother has sole responsibility. Please, there's no school letter which says that Akuya Tenewa is a pupil to student at this school. We recommend her for a visa. Please, we're not recommending people for visas. We're saying that express a professional opinion as to what this mother does with the school, and whether you can even go further and say that this mother or this father has sole responsibility. And we say that because the other parent has never called the school or has never visited the school.
I have pre-settled, but I don't have a card. Can I travel with my pre-settled status without the card?
Well, here you won't have a problem because when you arrive, they will check you online. From December 2024, all the cards will go away. We will be traveling with electronic visas. It started already for the European people and some other people. They do the electronic travel authorization, the ETA, which means that there's no visa in your passport, there's no visa in your pocket, there's no card in your pocket, but you're working. You're a working computer. You're a working digitalization. So when they take your person, they take your passport and they put your details in the system, they will see you. It's the same way that you can do your share code. It's the same way that you can do it. But when you're coming from Kotoka, and all the problems are at Kotoka, that is where the immigration officer will, and the airline, because you see when you're traveling British Airways, they have an iPad and they take a picture of your passport, if it's a British passport. If it's a Ghana passport, they take it with your biometric card. If you don't have a biometric card, it doesn't matter how beautiful or handsome you look, they will send you back home. So please, don't travel without your card.
Well, we're moving and soldiering on. We just got a few more minutes to go. And remember, we coming your way, courtesy BWF Solicitors. And there's this exciting bit about this program that I'm getting into now, where I ask you a question and I test your knowledge as to whether, one, you've been following BWF Solicitors all throughout the week, or the practical lessons we bring you, you are quite grasping them and working with them. People feel so empowered to do things on their own with the help of these discussions that we've been having, especially on our platforms on Thursdays, Fridays, and Saturday afternoon. So I'm going to just take a step back and come back with my question as a scenario that I'm going to give you. And in that scenario, I'm going to test whether you understood this nuggets that I brought you. Can we look at it again quickly before I go? Now, no recourse to public funds, often referred to or shortened as NRPF. It is an immigration condition that stops people from accessing benefits, also called public funds, such as homelessness assistance and universal credit. However, social services have the power under Section 17 of the Children Act to provide financial assistance and accommodation to the whole family of the child in need. This support can be provided to the child's parents. This is quoted from R on the application of OA and others versus Bexley LBC 2020 case EWHC 1107 and administration. We'll be right back, and when we come is the quiz.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, yes, you are still there. So I am happy to take you through that. And listen, Uncle Ben is here, so he's going to help us answer the question. But I want to test you first. So let's go to the quiz, and I will get you the scenario. Now let's start with this one. It says, the Lumba family are a family of 2 parents and 3 children living in the UK without lawful residence. The children were 3, 7, and 17. They lived in the UK for 3 years, having arrived as visitors. They became homeless and destitute, living on the streets. They approached the council for accommodation and support. So let's look at the scenario again very carefully. This family, Lumba family, 2 parents and 3 children without lawful residence. The children were 7, 3, and 17, and have lived in the UK since they arrived as visitors. Let me put it that way. They became homeless and destitute, living on the street. They approached the council for accommodation and support. What is likely to be the council's decision? The council does not have a duty to support them because they came into the UK as visitors and have overstayed. The council has a duty under Section 17 of the Children's Act to assess and support the family. 3, they have to renew their visa before they can get the support. What is the answer? These people came in, 2 parents, mom and dad, and 3 children, 1, 3, 7, and 17 when they came. They lived in the UK for 3 years, having arrived as visitors. At a point, unfortunately, they became homeless and destitute, and they were living on the street. And I remember Uncle Ben advised that no matter what it is, approach the council. Tell them you are applying for support because the children under the law have to be catered for. Have I answered the question? Anyway, let's see. So let's go on to platform and see how many are answering. Now, the options are: the council does not have a duty to support them because they came to the UK as visitors and overstayed. 2, the council has a duty under Section 17 of the Children's Act to assess and support the family. And 3, they have to renew their visa before they can get support. Okay, let's see. Which one was the first one that came? Sandra Fraser says number 2. Okay. Anita Ajapoma Japong says number 2. Sarah says number 2. Naomi, okay. Naomi gives a further explanation. Let's see what she says. Because of the children, is number 2 because of the children? Well, the children are involved in all 3 answers, aren't they? Okay, so Isaac Amwako on YouTube says number 2. Ricky Botche says number 2. Okay, number 2 seems to be very popular. Tilly Duma says number 2. Richard Dogbe says number 2. Margaret Edumensa says number 2. What is number 2 saying? The council has a duty under Section 17 of the Children's Act to assess and support the family. Is it true? Let's go to the nugget. Maybe before Uncle Ben comes in. Okay, Patience Amatefio also says number 2. The nugget says what? No recourse to public funds, often shortened as NRPF, is an immigration condition that stops people from accessing benefits called public funds, such as homelessness and homelessness assistance and universal credit. However, social services have the power under Section 17 of the Children's Act to provide financial assistance and accommodation to the whole family of the child in need. The support is provided to the child's parents. I was going to ask this question. Maybe I'll ask you before we go back to the question. No, let's go back to the nugget. Is social services obliged? I've asked it, but I'm asking again. Can they say, or we may, after the assessment, say that you are not qualified? Or once an application is made under Section 17, it is an obligation for social services, no matter what, no matter how they delay, to provide that assistance. Is that recommended?
Okay. Yes. So now you've situated a question differently. There's a difference between an assessment and there's a difference between a duty.
Okay.
So the duty to assess and if qualified to pay is a duty that derives from law. So when someone who is destitute or potentially destitute approaches the council, all the councils have their portals where you have to complete forms online or call their telephone line. They will have to assess you. The duty to assess is compulsory. They have to assess you. Upon assessment, they can make one of two judgments. You qualify, we will support you. You don't qualify, we will not support you. What I find is local authorities running away from their duties saying, oh, you don't qualify. Oh, you don't qualify. Go and make an application before we support you. We've looked at case law before, I think last year, where the advice was to put in some form of application before approaching them. But if somebody has no recourse to public funds, that comes under Section 115 of the 2019 Immigration Act, which says that any person who is subject to immigration control will not have recourse to public funds. So the local authority, both under the National Assistance Act 1946, the Children Act 1989, Section 17, will have a duty to provide for children in their locality who are destitute or potentially destitute.
Okay. Well, then I think I'll go back to my question and see who. In fact, it looks like everybody says it's number 2. Section 17 coming in there kind of gives you a clue, so everybody is talking about number 2. My T show is on tomorrow afternoon on Facebook, and I know Uncle Ben is featuring on there again. Is that correct, Uncle Ben? Yeah. Okay.
The GAR program.
Yeah, it's a GAR program, and is one of the avenues through which BWF Solicitors educates the community. So if you have a challenge of understanding the Twi language, you have a challenge of following very well in English, and you're a GAR, that's another platform for you. Sundays, 2 p.m. British Summer Time. So make a date tomorrow afternoon, the Na Manyeti Show live on Facebook and YouTube. Now, the family is destitute. They've approached the council, and everybody says the answer is number 2. Uncle Ben, are we correct?
That is why we've always, when we did a nugget as no recourse to public funds. So if you don't have status, you don't have public recourse to public funds. If you have status, sometimes you still don't have recourse to public funds. In this case, the Lumba family, the family of 3, but they are destitute and homeless. So already you can see that, they will fit the definition of people who come under either the National Assistance Act, but in this case, the relevant rule will be section 17 of the 1989 Children Act. So the answer will be 2, because the council has a duty under section 17 of the Children Act to assess. So when you see there, you see to assess and support the family. So it's 2 duties. They have to assess, they make a decision, and then they have to support. The support comes in the form of accommodation and subsistence. So they give you vouchers and accommodation, they put you in a hotel, or they rent a place for you.
Okay. Well, as Uncle Ben said, the answer is number 2. The council was able to do so under Section 17.3 of the Children's Act of 1989. The power to support the family could be exercised with respect to any family member and is not limited to a parent or a carer. So, listen, don't shy away. Approach the council. The law gives them the mandate to assess you and also support you. Homelessness is not any situation I would want to wish on anybody. If you are destitute, yes, you found yourself in a very difficult situation, and the society has to help. So, irrespective of your status, irrespective of the fact that you may be having no recourse to public funds on your status, you don't have to be destitute. You don't have to be homeless. Get a roof over your head, and your children will thank you because they need to be catered for. Well, that's that. So next week, I'll be bringing you another segment of the nugget and then a quiz. So watch out. So watch out for BWF Solicitors every Monday when the nugget comes out. And what makes it so beautiful is that there's the Monday motivation that kicks it all going so very well. So when it comes out, put it on your status, enjoy it. People will love it because it would inspire people to work very hard in the week. With this, I go back to Uncle Ben and ask him to do a quick summary of what we have done. Then we'll draw the curtains down on the program. Remember, we discussed practical steps to take when you are making an application for your child to join you and to settle with you here in the UK. Uncle Ben.
Yeah, Kweku, thank you very much. We've looked at the practical steps to make a successful settlement application. And we said evidence is a game. Evidence is a game because when you make your application, you have to support it with evidence. Some of the evidence will be the relationship proof, which will be the birth certificate or DNA. But crucially, where one parent is here, or even where 2 parents are here, the issue of sole responsibility will always crop up. We gave you a sample letter, a template for you to copy so that you can use it for your applications. We also showed you how, in reality, this evidence is assessed by the Home Office or by the court. We saw that when it comes to the assessment of this evidence, the burden of proof is on you. The standard of proof is the reasonable probabilities, which means that it's a civil standard, which is slightly lower than a criminal burden of proof, beyond reasonable doubt. So that's beyond reasonable doubt, or the preponderance of evidence, is the standard. So we've also learned that under the case law of TD Yemen, the court said that the assessment of sole responsibility is factual. And that's why we've advised you that when you make your application, take a letter from the church, ask the pastor to write a nice letter. Please, no recommendation, no testimonial. So the pastor is not going to say, there's a testimonial to say that Kia Tinewa comes to church and she's a good girl. I recommend her for a visa. That's not what we're saying. What we're saying is that the pastor will take his time to say that I know Kia Tinewa. I've known her since her mother was in Ghana or when she was born. I've been a pastor of this church for the past 15 years. And she used to come to church. Her mother is now in the UK. And her mother calls regularly to speak to me about her religious progress. I can confidently say, my professional opinion, that she has sole responsibility and the other parent is not in her life. Period. The same letter could be sent to a professional, a social worker, a doctor, a school, and they will do the same things. So what you're doing is that in addition to the money transfer receipts, your visa travel stamps in your passport, itinerary, telephone calls with your daughter or your son that you've got. You're also getting this independent evidence from professionals and institutions whose view or professional view carries weight. So that when it comes to weighing of the evidence, the Home Office is supposed to give weight to the evidence. We mentioned the 5 thematic areas of education, finance and maintenance, of health, of religion, church, and then others. Others include vacation, where they take their vacation, who decides that friends they make, and all other things. The letter that we showed covered all those areas. Once you gather your evidence, you can make your application, you upload your evidence, you keep the originals. When they take their biometric, they will make a decision. If you've made an application already, as David asked during our presentation, you can now send this evidence to them by email and say that we've got this new evidence, you haven't made a decision, I'm proactively sending this evidence to you. And they will use it. Once you give it to them before they make a decision, it will be considered as part of the application. Ladies and gentlemen, this topic was repeated again and again and again because we've identified a trend. And that's why we want to ensure that the community is provided with the necessary information so that when they're making the applications, they can make it with informed judgment.
And with that, I would want to say thank you very much, Uncle Ben, for your time, your patience, the dexterity with which you presented this topic, the practical steps, as the topic in itself indicated, and of course, sharing evidence that people would want to hold so close to their chest, but you have given. I remember Uncle Ben saying lawyers can copy that and the rest of it. Yes, that's a template and work with that. And that's what you get from BWF Solicitors, our trusted partners when it comes to the law. 214-218 Tottenham High Road, Seven Sisters. That's where they are on the 4th floor of the Anna House. Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, you can find them. So walk in there and make sure you are satisfied. It's the only law firm that gives you chocolate when you go in there. What else do you want? Come to BWF Solicitors. Call them 0208-493-7340 and 077-127-61884. Uncle Ben, thank you. Thank you so very much. We're very much grateful. And to everybody that's at BWF Solicitors, Lawyer Eunice, Lawyer Charles Asma, Auntie Cynthia, Sandra, and I always forget the beautiful young ladies who are here. Listen, Annie and the rest of you, forgive me if I don't mention your names. I am so grateful to all of you. Now, if you come in, the attention to detail and the welcome they give you is unrivaled. That's why I would want to say, and I've said it over and again, that I don't owe anybody any application when I vouch for BWF Solicitors. Thank you very much, Uncle Ben. We will be looking forward to be having you very soon on the program again. So on behalf of my studio producer, Professor Ades, Sheila Ankra and Padmo Dudu for the Statistics and Administration, and to my folks who are out there, Tilly Duma and the family, and everybody that's been part of the program today. If you didn't watch the live one, don't worry. The link will be on there and you can watch it over and over again and share with people. But tell them we'll be coming again same time next week on the same platform. And until then, it's good evening.